12 common pitfalls to do-it-yourself estate planning. Number 1, not naming a beneficiary. Many people never name a beneficiary for retirement or life insurance. If you do not name a beneficiary for life insurance or retirement, then the financial company has its own rules about where the assets will go after you pass. For life insurance, typically the proceeds will be paid to your estate. This means your family will need to hire an attorney, go to court, and probate your estate to claim the proceeds. For retirement benefits, if you're married, your spouse will most likely receive the benefit. But if you're not, the retirement account will likely be paid to your estate, which has unpleasant income tax ramifications. Number 2, getting the name wrong or not exactly right. Sometimes individuals fill out their beneficiary designation forms incorrectly. Not having names match exactly can cause delays in payouts, and in a worst case scenario of 2 people with similar names, it can result in litigation. Number 3, forgetting to update your beneficiaries over time. Who you want to or should name as a beneficiary will most likely change over time as circumstances change. Naming a beneficiary is part of an overall estate plan. Just as life changes, so should your estate plan. Number 4, losing control by adding someone to your bank account. When you simply add someone's name to your account, you are subjecting that account to his or her creditors. You don't have to be a bad person to be sued these days. Anybody can be subject to a lien. You may also be inadvertently giving that person an ownership interest in your account. Number 5, putting your children on title to your home. When you put your home in co-ownership with your child becomes co-owners of the property with you. This causes many problems, but 2 of them are, number 1, the property could be subject to your child's creditors and predators. For example, if there are any lawsuits against him or her, or if they are going through a divorce, to name a few. Second, when they go to sell the property, there will likely be a large capital gains tax, as they would receive it at the value you purchased it at, not at the value of what the home is worth when they sell it. Number 6, failure to protect the disabled beneficiary. If you have a disabled beneficiary, perhaps a handicapped child, and leave the inheritance to them outright, they may be disqualified from receiving any more public assistance until they spend the inheritance down. Number 7, failure to make special provisions for a problem child. After you are gone, will your beneficiaries use their inheritance in a constructive manner, or will they waste it foolishly? How are they today managing their money? That may give you some idea as to how their inheritance will be spent after you are gone. Will it be available for the education of your grandchildren? Or will it be gone in just a few years? Number 8, trying to leave property to a minor child or grandchild. Because children are not legally competent, they will not be able to claim the assets. A court-appointed person, known as a conservator, will have to claim and manage the money until the minor turns 18. Conservatorships can be very costly and require annual accountings to the court. Number 9, failure to fund your living trust. By not titling assets in the name of the trust, they defeated at a minimum the main purpose of estate planning goal, which was avoiding probate. Number 10, assuming that all estate plans are equal. There is no such thing as a standard living trust. Assuming that all estate plans are basically the same can be a costly error. Number 11, not pre-planning for nursing home care. At an average cost of nursing home care at $12,000 a month, it is not difficult to lose everything you worked so hard to save for. Many people who need nursing home care will end up using Medicaid, but they cannot qualify until they exhaust their financial resources first. Number 12, not having an estate plan at all. If you don't have an estate plan, most states have one for you, and it may not be what you would want. Not many people would purposely let their state legislature draft their estate plan for them. Yet, that is what you get if you don't plan yourself. For instance, under Pennsylvania law, if you are married with children, your property would be split equally between the surviving spouse and your children if you have no plan. We find that is rarely what our married clients want. Most couples want to give more control over their assets to their surviving spouse and see their kids get an inheritance only after they both are gone. Choosing and creating a trust can be a complex process. The best way for you to determine whether or not your estate plan should include a trust is to schedule a meeting with one of our attorneys to discuss your planning goals and needs. This will empower you to feel 100% confident that you have the right combination of planning solutions in place for your family's unique circumstance. If you are interested in learning more, please click here or call us at 610-897-8994 to schedule an appointment today to get started. I thank you for your time and look forward to helping you achieve your estate planning goals.